there was a struggle and contribution by some young people. Some of them are here, and the pressure of the times which made the then government to bring the act of its own, because the constitutional position of the state gives it a space to have some laws of its own passed by the state legislature. It is not totally replica of the Central Act. In 2-3 aspects, it is more important and stronger than the Central Act. It has placed a bar on the Commission to dispose of appeals within a set time, so that pendency is very minimal. It has asked the first appellate authorities, though in default, that they will report to the Commission about the default committed by PIOs, to whom you call CPIOs. With all these provisions, and other provisions are the same which are there in the Central Act. Now, like other commissions, we have a very vibrant civil society there who may not be totally satisfied with the outcome. Complaint is persistent that, sir, there is delay. Of course, there is delay, but my little understanding of the Act Parlas since 2005, when it was introduced in Center, I attribute some reasons to the users of the Act. Section 7 clearly lays down that information, that response to the application will be given as expeditiously as necessary, but not later than 30 days. 99% of PIOs, first appellate authorities, are under this perception that information in any case has to be given within 30 days, though it is outer limit. In my opinion, I have been advising the users of the Act, if they write in the very application that I want this information within 7 days, within 8 days, then in my opinion may be faulted, because we have great legal luminaries in this house. It is the PIO who has to record the reasons somewhere and intimate those reasons to the seeker that providing information within 7 days may not be possible because of the following reasons. If there is no such reason on the record, no such communication to the information seeker, then my opinion is there that Commission is well within its powers to initiate the penalty proceeding. Not impose it, but initiation is necessary step. But ball is in the court of the users. Now, users would also, I request them, before jumping to the conclusions, that they should go through the preamble of the Act. It is the same preamble which is there in the Central Act. Professor Marvan gave us yesterday an illuminated talk on the preamble. It is my humble opinion that most of the commissioners also, including me, have not emphasized the importance of the preamble. It lays down the purpose of the Act. But what is the purpose of the Act? To bring transparency and accountability in the working of public authorities and nothing else. Users of the Act must know that this is the only purpose for which this Act has to be used, no other personal vendetta, no other agenda. Because just before attending this commission, we were seized at Jammu full bank with a serious issue, and solution was given in the evening by the Honorable High Court by staying the proceedings. Now then, if purpose is there that for securing transparency and accountability, then what is the role of the Commission? We have also failed commissioners to, because I have not seen any order where this is mentioned that commission is saddled with the responsibility to reconcile the conflicting interests. What are conflicting interests? They are that the information giver says that it is my honored treasure, file is my honored treasure, how can I give it to an ordinary person? And the seeker says that under sun everything is to be given, whether it is a personal information or it is an information which has to be given, which is under the possession and control of the public authorities. Because for last some time now I have been used, though we have been directing that information may be disclosed, but if commission would like to know after some time what is the user of this information. There may be a debate on this whether it is legally tenable or not. Now commissions, we should also know that the administering this act is purely a quasi-judicial process and not an administrative process. Till this time, it is my observation for last 5 years, and my colleagues also, most of the PIOs are treating it as an administrative action, which it is not. We have been emphasizing to all these PIOs that it is a quasi-judicial authority, and you are personally responsible for providing or denying the information, no reference to a boss. I had a unique case where there was a delay of nearly 6-8 months. Information was very, what we call, unharmful. I asked the PIO, why you have delayed this too much? He said, sir, I have to refer the case to the authorities. I called the record for next hearing, and I found he was an undersecretary, as the instructions are there that minimum PIO should be of the level of an undersecretary. He had marked it to his deputy secretary. I read that order sheet or note sheet, whatever you may call it, because in my earlier avatar I used to call it order sheet. Just noting is there, tip to deputy secretary. Reaches deputy secretary after 5-10 days, he takes his own time. When he disposes of, he just puts a googly, I call it, just a signature, initials, returns to additional secretary senior. He also does the same process. Then there is additional secretary, no, it was junior, some problems, then another secretary, then it goes to special secretary, ultimately it goes to secretary. And secretary returns file with a sign. And information is later on given. But there is a constant delay of more than 6 months. I narrated the entire sequence in my order, and order was even published in newspapers there. What I want to emphasize is that the office, I think it is commissions who have failed to educate the PIOs and CPIOs that, Baba, this is a quasi-judicial function. This is not a function where you are referring it to your bosses, because penalty section 19, your RTI Act, and J&K State section 17, penalty is a personalized penalty on the PIO. It is not on First Appellate Authority or the secretary who ultimately sent the file. Now, this act has made elaborate system of how to make it how to publicize, how to take steps to see that this act reaches to the most disadvantaged sections of the society. Government has to make programs. Without an exception, I think most of the departments of government fail to do that. Excepting some few acts. The commission, when we started functioning in 2011, though the act was made in 2009, but commission was appointed in 2011, I as Chief Commissioner, the administration took further 6-8 months to appoint, give me 2 more commissioners so that quorum is full. I was not taking very important decisions because I knew what is the legal implication of taking certain decisions. Because judiciary is fortunately or unfortunately quite active on RTI front. Now this is the problem that why these delays are there. Yesterday, we had a discussion on the findings of a credible NGO. I respect them. They said that why commissions are reticent in imposing penalties. It is a fact that we are saddled with the legal duty to impose penalty if there are no reasonable cause for delay or for furnishing inaccurate and incorrect information. But this is not the fault of only commission. The wording of this section is overwhelmingly in favor of the implementers, because it is written that malafide has to be established before you impose penalty, particularly in the case where information is claimed to be incorrect. I have been dealing this concept of penalties when they have to be imposed. What is the natural opportunity of giving this natural justice of providing penalty? Then it has to be speaking order. Since 1970s, I have been dealing with concept, and in how many cases then judiciary is sustaining your orders. Commissions are, it is my humble opinion, that we should rise to the occasion. If I tell that PIOs are a judicial institution, we are doubly that judicial institution. We should not pass orders in which we receive criticism in a very non-speaking manner, because they are to be subjected to judicial review. And State Commission of Jammu has tried to come to the expectations, come to the level of that judicial scrutiny. Similarly, from the administration side, yesterday we had Honorable Secretary DOPT, and he made certain, rather it was a compassionate plea that something should be done to stop what he calls vexatious applications. But I will tell, it is the failure of the administration which has risen, particularly go through central rules. Every state has formulated its rules because law gives power, rule-making power is with the state government. It is only substantive law which has to be passed by parliament or state legislatures. All other states, including J&K state, we had wonderful rules of 2009-10. But when commission started work, within a period of 9 or 10 months, they were abruptly repealed and replaced with central rules. Because Mr. Sanjay ji yesterday made a plea to the commission to come up with suggestions. See the contradiction in the rules regarding the presence of complainants before the commission or appellants. They are told, it is written there that he may come, he may not come, for both the proceedings. Appeal/complaint. In complaint section, which is section 18 of Central Act, mine section 15, commission is empowered with the powers of a civil judge while conducting a trial of the suit. And in the very first clause, we are required to hear the parties. Here there are rules, and they say that person that you need not go or you may go. We are faced with a stay on this issue. Therefore, the implementers, users, and lawmakers have to balance these problems, because the preamble itself says it is the duty of the Commission to balance, to reconcile these differences. I would request Central Information Commission, because my commission for last 4 years has been trying its best to convince the administration to bring rules where first commission will be strengthened, commission will be regularized, and this means or the allegation, whatever one may say, harassment or misuse, because the legal in law there is a very strong concept of misuse of legal process. These are allegations with respect to some few people, but few people create problems for the administration and it give handle to them to maybe in future tinker away with the act itself. We have to take a call. Central Information Commission, because you are the focal point of all commissions, I would request them that kindly go through the central rules particularly. See those rules with Gujarat rules or this UP rules or Karnataka rules, and see what there is no this symmetry, and they are not enough to meet the challenges which we are faced daily. In my note to Honorable CIC, we had given number of success stories. I will shortly come this now. I will not discuss too much because we have very limited time at our disposal. There are numerous success stories. It is this act which every one of this country should protect it. Could someone imagine that some young boy appearing in PSC, state PSC, being declared that he has failed, invokes RTI, and 2 years RTI is being refused by the state PSC, saying that we are a constitutional institution, we don't come under the net. And when commission is appointed, he gets an order, very strong and favorable order, that disclose papers to him, and when question papers are seen, it is found that he had qualified and he should be on the middle of the list. And the commission was also very credible, gives the recommendation to the state government, appoint him with retrospective effect. And after 3 months, he appears before the commission as PIO of the Home Department. There are a number of numerous, it has done wonders to the people. It has done wonders to the people. But my fervent request to the users would be, see to it that it is not used just because some officer did not offer a chair. Arey ab main dekhunga tumhe, dekhunga kya hai? That next day he gets RTA application, and it is against the use. All commissioners should consider this preamble, and the Honorable Supreme Court's decision that disclosure is a general rule. Keep preamble in view and coupled it with the observation of Honorable Supreme Court in that famous case that disclosure is a general rule, denial of information is an exception. If this harmony is done, then I think there won't be much problems. Similarly, harmony has to be done, as we heard since yesterday, on Section 8. Recently, I decided a case where J&K police, they are very prompt in complying, but sometimes interpretation is different. They were asked to give the list of SOPs, Special Operational Procedural Standards. No, SOP. Durant reply is there, meeting the deadline of 30 days. This is against the national sovereignty and security of India, hence denied. Then commission gave the information, everything was disclosed. In another serious problem, a very good smart young RTA activist brought the commission's attention to last provision of Section 8, where it says that even the information which is otherwise exempted under the Act has to be disclosed if larger public interest is if largest public interest is there. It's a revolutionary thing. Even Section 8 does not remain always prohibitive. If a case is made, case has to be made. I would request these NGOs and users of the Act that they cannot blame only Commission. They have to make a case. That's last subclause of Section 8 is involved, is applicable. If it is applicable, we will be glad to apply the law. But if there is a shady representation, if the information seeker says, "Sir, मैं तो नहीं आ जाऊंगा Commission के पास," then how these conflicts will be resolved? They will go at the drop of the hat to the High Court and get a stay. It cannot happen. I think I have taken much time. With these initial observations, I would like Mr. Jain to give his presentation.